What is the role of a trustee? The trustee is the person who manages all the property and assets that are in a trust. A trustee has a fiduciary duty to act in the best interests of the trust and its beneficiaries with regard to that property. Individuals and couples often decide to put some or all of their assets into a trust for estate planning purposes. This legal arrangement can include aspects of a power of attorney and last will and testament, and add clarity for loved ones after you're gone. While they're still alive, many people choose to be the trustee of their own trusts. However, once you pass, your trust and will are going to have appointed a new trustee or an executor in the case of a will to take care of your assets. You should ensure that whoever these people are, they're aware of their responsibility and ready to handle your affairs whenever the time is right. What does it mean if you're a trustee? Being a trustee means you're legally responsible for managing the trust assets and making the distributions for which it calls. California law outlines numerous legal duties for trustees, including 1. Administering the trust by the terms of the document, 2. Being loyal to the beneficiaries of the trust, 3. Dealing with those beneficiaries impartially, 4. Avoiding conflicts of interest between you and the trust or its beneficiaries, 5. Legally segregating and identifying trust property, and 6. Prudently managing and investing the trust assets to make them productive. As you can see, being a trustee requires taking on a lot of active roles. It's not an easy job, and therefore trustees can be paid for their work out of the trust assets. However, due to their duties that they owe to the beneficiaries, the trustees cannot overcompensate themselves for the work that they do. What does a trustee do when someone dies? When you become a trustee after a grantor's death, the first thing you need to do is identify and secure the trust property. It's called marshaling the properties. You locate the governing trust documents and take an inventory of all of the assets. Ensure you have control and access to all of the trust property, or if you don't, get access. For example, if one of the trust assets is a piece of real estate, which is most common, you need to locate the deed and ensure the trust has clean title to the property. If the trust has a significant investment account, you need to present your credentials to the investment firm so that you can access the account online, in person, whatever you need. The next step is to consult with professional financial managers, tax advisors, perhaps real estate professionals, etc. As a trustee, you're responsible for paying the trust's debts, including its taxes, and setting up a responsible investment strategy. You may need to pay for appraisals of land, property, or other valuable assets such as jewelry to have a firm grasp of the extent and nature of the trust's assets. Once all those tasks are accomplished, you can begin distributing assets to the beneficiaries as outlined in the trust. Who has more rights, a trustee or beneficiary? There's another set of duties imposed on trustees by California law, and these focus on making sure a trustee is responsive to its beneficiaries. As a trustee, you have duties to 1. Supply the terms of the trust to beneficiaries upon request, 2. Inform the beneficiaries of any significant events, 3. Provide an accounting to beneficiaries upon request, 4. Inform other beneficiaries if you receive a request from another beneficiary. Beneficiaries have the right to request all these documents from a trustee. However, if they disagree with the trustee's decisions and the trustee is not open to their feedback, then really their only remedy is to go through the probate court to hold that trustee accountable. Conflicts between trustees and beneficiaries are resolved in probate court. Typically, probate court is hesitant to interfere in trust management. Therefore, as a beneficiary, you're going to have a compelling reason and evidence of mismanagement or distributions gone awry by a trustee to get some relief. Whether you're a trustee or a beneficiary, these types of conflicts can be complicated and time-consuming. Your best bet in these scenarios is to consult with an experienced probate litigation attorney as soon as that conflict arises, so you know which is the best course of action to take. Have questions? Give us a call, shoot us an email anytime. At RMO, we protect people like you every day. Thanks for watching.